Good afternoon, everyone. The IHL Clinic from the Federal University of Rio Grande do Sul is very pleased to have you all here today to listen to and learn from Arthur Traldi on the ICC inquiry into Boko Haram in Nigeria. Arthur is a senior counsel at the Louis de Brandy Center for Human Rights Under Law, a senior consultant with LexPat Global Services, a senior fellow with the Technology Law and Security Program at the American University, and an adjunct at Villanova University Law School. Arthur received his JD from Georgetown University Law Center and his undergraduate degree from the College of William and Mary. He's an expert panelist with Trial Watch, a member of the American Bar Association's International Criminal Justice Standards Advisory Group, and a past co-chair of the International Criminal Law Committee. From 2010 to 2017, Arthur served as a prosecutor at the International Criminal Tribunal for the former Yugoslavia, litigating cases involving charges of genocide, crimes against humanity, and violations of the laws of armed conflict. Arthur has also served on teams making submissions to the International Criminal Court, United States Supreme Court, European Court of Human Rights, and other courts in the US and abroad. Also, before joining the ICTY, he served in chambers at the International Criminal Tribunal for Rwanda. So, Arthur, I would like to thank you for your time in advance. It's the second time that you are here in the clinic with us, and it's very nice to have you, and the floor is yours now.
Thanks, Louisa, and thanks to all of you at UFRGS and at the clinic. It's a real pleasure to be here with you again. And fair dues to those of you who share my willingness, even desire, to talk about atrocity crimes on a Friday evening. I appreciate that very generous introduction. And of course, while Louisa mentioned a number of the organizations that I've had the privilege to work with over the years, I'm speaking just for myself tonight. So I want to try to give a bottom line up front for this talk. And the takeaway I'd give you or ask you to take from this is the International Criminal Court and people who study it appear to be paying really insufficient attention to Nigerian victims of atrocity crimes, including some very high-profile victims of exactly the sort of crime that the court is supposed to be focusing on. So let me step back a little from that kind of macro thought. This talk and the chapter it's based on are called Bring Justice to Our Girls, with a question mark in the chapter. And of course, that's a rewrite of the slogan that was the first way a lot of people heard about the crimes that the ICC is considering in Nigeria, the hashtag Bring Back Our Girls, which was a really big deal in 2014. That hashtag responded to the kidnapping of almost 300 teenagers in Chibok in Nigeria by a group called Boko Haram that's been allegedly responsible for many of the most serious international crimes in Nigeria over the past 15 years. That kidnapping, on the night of 14 April 2014, over 200 Boko Haram fighters burst into a dormitory at the Chibok Government Girls Secondary School. From media reports, it appears the girls there were getting ready for exams. Many would be graduating afterwards and about to start their careers. The fighters told the girls to go outside, stole the food from the school's storeroom, and then set fire to the storeroom, loaded the girls onto pickup trucks, and drove away into the forest. A few dozen of the girls escaped that night, and there's actually been an uptick in rescues recently. I was reading today in preparation to talk with you that at least 20 have apparently been reportedly rescued in the last year, but still more than 100 are missing, and reports indicate that some have died. Boko Haram's leader, a guy named Abubakar Shekau at the time of the kidnapping, reportedly issued a lengthy statement taking responsibility for the kidnapping, calling the schoolgirls slaves, and threatening to sell them. There are a few things that illustrates that we'll come back to when we talk about the ICC investigation, about the alleged crimes in Nigeria. The targeting of civilians, of women particularly, of educational institutions. Boko Haram's name loosely translates to Western education is forbidden. The targeting of religious minorities, in this case Christians. the use of crimes of sexual and gender-based violence, as in Shekau's threat to sell the girls, and the particular harrowing impact of this conflict and of the crimes alleged against this particular group on children. So that kind of baseline reality, I think, is really important to keep in mind as we talk about the legal issues, the legal principles and technicalities that are at stake in this situation. With that, I do want to talk about that legal framework. And I want to keep a few things in mind. So I focus on the International Criminal Court's inquiry into Boko Haram in Nigeria, which means we should remember what the International Criminal Court is. The International Criminal Court is a creature of a treaty, the Rome Statute. It's a court of delegated jurisdiction. What that term means is that it gets its jurisdictions from the state to sign on, from states that sign on to the treaty, like Nigeria. There are controversies about edge cases, like if a state tries to delegate jurisdiction over a crime committed by a person who's not a national of that state, for instance. But this isn't one of those edge cases. Nigeria signed up to join the court, and it can consent to the court's jurisdiction over its own nationals, and that's most of the alleged perpetrators. State parties delegate jurisdiction to the ICC to prosecute three primary categories of crimes: genocide, those crimes against humanity which are defined in the Rome Statute, and those war crimes which are defined in the Rome Statute. Some state parties have also given the court jurisdiction over the crime of aggression in some circumstances. But the ICC doesn't take jurisdiction over a single crime, even as something as serious as this kidnapping. At least not to start. It takes jurisdiction over what it calls a situation, meaning all the crimes within its jurisdiction, that is, falling within that subject matter grant, genocide, certain war crimes, certain crimes against humanity that are enumerated in the Rome Statute, all the crimes within its subject matter jurisdiction that are committed within a geographic area, within a particular range of time. For instance, here, it's looking into what it calls the situation in Nigeria. Not just alleged crimes allegedly by Boko Haram, but alleged crimes by other groups committed in Nigeria in the same time period, roughly the last 15 years. Once it starts looking at a situation, the court essentially goes through three stages. At first, it does what's called a preliminary examination. What a preliminary examination means is a little bit more preliminary than examination in the typical way we use those terms. The court is passively receiving, the Office of the Prosecutor is passively receiving open source information and information from stakeholders and interested parties like NGOs. But it's not going out and collecting evidence, doing a full investigation on its own. If that information that it's provided gives it reason to believe that crimes within ICC's jurisdiction have been committed, then it determines whether any of those alleged crimes may lead to admissible cases against individuals who may be criminally responsible for them. And we'll talk about the admissibility test in a moment. But if it does, it moves forward to an investigation. It doesn't have police, but it does have investigators, and this looks more like a traditional domestic investigation, like we're familiar with from our own experience or from television, where it goes out and gets evidence, collects evidence, places it in an evidence collection, bags it, tags it, does interviews with witnesses, and issues arrest warrants. If it brings a case against a particular individual, then before the case goes to trial, the judges will decide if it falls within the court's jurisdiction, within the right place and time. If the charges fall within the court's jurisdiction because they're in the Rome Statute. And then they'll consider whether it meets the two primary criteria for admissibility. First, they'll ask if the crime is of sufficient gravity. What that means is whether it's bad enough for the court to spend resources on in a world where there's plenty of bad things that happen at any given time. Second, they'll ask if the court is barred from hearing the case, if it's inadmissible, because of what's called complementarity, the rule that ICC doesn't come first. So if another court with jurisdiction is prosecuting the case, that other court gets priority. So the 4 rules for ICC to take a case, bottom lining it are, first, jurisdiction has to be delegated from someone who can delegate it. Second, the case has to deal with one of just a few categories of crimes. Third, it has to be worth prioritizing. It has to be bad enough to be worth prioritizing. And fourth, it has to not be being handled somewhere else, not be being handled in a domestic court. So what's going on in this situation? ICC had started looking at allegations against Boko Haram by 2010, years before the Chibok kidnapping. 3 years later, still before the kidnapping, and 10 years ago now, ICC had already determined a few things. They found in 2013 a reasonable basis to believe that, as they put it, since July 2009, Boko Haram had committed the following acts constituting crimes against humanity. First, murder under Article 7.1a of the Rome Statute. Second, persecution. And they concluded that they had a reasonable basis to believe that they had launched a widespread and systematic attack, what distinguishes a crime against humanity from other types of crimes, that resulted in the killing of more than 1,200 civilians, Christians and Muslims, in different locations throughout Nigeria. And that those attacks were committed pursuant to an organizational policy within Boko Haram aimed at imposing a religiously exclusive system of government in northern Nigeria. And that meant that not just people from different religions, but people who opposed that goal of religiously exclusive government were targeted for violence. And they say civilians were the primary object of the attacks, and they were not a randomly selected group of individuals. Instead, Christian worshipers were targeted, local politicians, community leaders, and Muslim clerics opposed to the group were targeted. They noted it claimed responsibility for bombing churches, banks, and beer parlors in northern Nigeria, as well as a United Nations building and a police headquarters, and at least 12 schools. So that's 10 years ago that it was able to reach all those conclusions. This matched a US State Department designation of Boko Haram as a foreign terrorist organization a few months later, listing similar violations. And the next year, Amnesty International estimated Boko Haram had kidnapped, setting the other crimes aside for a moment, had kidnapped more than 2,000 people, about 10 times as many as in the Chibok kidnapping. The conflict escalated from there, and the alleged crimes investigated, or the alleged crimes escalated. By 2019, the ICC's Office of the Prosecutor had identified admissible cases. So this took another 6 years after determining that they had subject matter jurisdiction because they had reason to believe these crimes were being committed. They identified 7, and I'll talk about them specifically a little bit later. By 2020, it declared that all the conditions had been met to open an investigation. Then Prosecutor Fatou Bensouda laid out what she found reason to believe that this group may have done. My office has concluded there is a reasonable basis to believe, she said, that members of Boko Haram and its splinter groups have committed the following acts constituting crimes against humanity and war crimes: murder, rape, sexual slavery, including forced pregnancy and forced marriage, enslavement, torture, cruel treatment, outrages upon personal dignity, taking of hostages, intentionally directing attacks against the civilian population or against individual civilians not taking direct part in hostilities, intentionally directing attacks against personnel, installations, material units, or vehicles involved in humanitarian assistance, intentionally directing attacks against buildings dedicated to education and to places of worship and similar institutions, conscripting and enlisting children under the age of 15 years and using them to participate actively in hostilities, persecution on gender and religious grounds, and what's an umbrella category, essentially, of other inhumane acts as a crime against humanity. And she acknowledged that the preliminary examination had taken a long time. She said the duration of it was due to her office prioritizing trying to help the Nigerian authorities do investigations into allegations against Boko Haram. But she concluded, our assessment is none of these proceedings relate even indirectly to the forms of conduct or categories of persons that would likely form the focus of my investigations, the investigations at the ICC. And while this does not foreclose the possibility for the authorities to conduct relevant and genuine proceedings, it does mean that, as things stand, the requirements under the statute are met for my office to proceed. So she's sharing here her view that crimes are grave enough and that complementarity doesn't preclude the ICC from moving forward to an investigation. There would be admissible cases. But she said, because of COVID and because of resource limitations in the office, remember this is December 2020, she'd leave it to her successor, the now prosecutor Karim Khan. Now, by that point, you may have heard in the chronology I gave, we started at 2010, we're now at December 2020. By then, it had already been one of the longest preliminary examinations in international criminal court history. The only other three to last for a decade are Afghanistan, Colombia, and Guinea. We'll hit 13 years of Nigeria preliminary examination. And the only one of those other three where we hit 13 years without OTP either closing the investigation or at least formally asking a chamber of pretrial judges to authorize an investigation was Colombia, where the domestic courts had established a whole system for dealing with the crimes that would have been under ICC's jurisdiction, and where ICC eventually determined that that system was sufficient to trigger complementarity. But at this point in the life of the preliminary examination, they were kind of monitoring it. So 13 years is unprecedented, basically, and we haven't seen public momentum since that announcement in December 2020, which means this is the longest time an ICC situation has spent in limbo, from where the OTP declares it has enough evidence to move to an investigation to when they actually take the next step, 2.5 years so far. The only other one I've found to wait more than 1 year was Ukraine, where OTP only moved to a full investigation after the escalated invasion last February, after declaring also in December 2020 that they had enough to move forward. In Afghanistan, it took a couple of years after OTP decided it had enough to move to an investigation, but most of that time was judicial decision-making about OTP's request to move forward. OTP itself moved more quickly. So let's talk for a moment about those cases, about what essentially has been left in limbo. Those 7 cases that ICC has identified. First, attacks on civilians, and there its own reports from my study of them indicate 10,000 or more civilians killed by this one group alone, more than they had evidence of at the same stage in almost any other situation they've ever looked at, particularly just looking at some that have recently led to not just investigations, but arrest warrants, trials, in some cases, arrest warrants and trials. Significantly more killed civilians, unlawfully killed people, than they had evidence of at the same stage in Mali or CAR 2, Central African Republic 2, Georgia, Cote d'Ivoire, or Kenya, for instance. In all of those, not only did they move forward, there were arrest warrants, and with the exception of Georgia, there were trials. This hits the war crimes. This reports of 10,000 or more civilians killed. While it doesn't conclusively prove war crimes, it hits the war crime. It triggers consideration of the war crimes of directing attacks against civilians, unlawful killings, and crimes against humanity of murder and extermination, because it's in the context of what OTP has found reason to believe is a widespread and systematic attack against civilians. So that's case 1, 10,000 or more dead civilians. And again, a number that's larger than the concrete number I've seen in almost any other ICC situation at this procedural stage. Second, abduction and detention of civilians. Those are kind of sterile words. So it's worth looking at what the evidence says happened to people who were abducted and detained. And from ICC's own reports and others, it includes abducting kids to use as soldiers, beating detainees, starving them, committing crimes, sexual and gender-based crimes against them, executing some. On the facts, it seems to include crimes of enslavement, unlawful imprisonment, and torture as crimes against humanity, and hostage-taking, torture, and cruel treatment as war crimes, as well as those crimes of sexual and gender-based violence and sometimes unlawful killings. The third case they've identified, attacks on schools, teachers, and students. And that includes, reportedly, the destruction of hundreds of schools just between 2013 and 2015. Attacking teachers and students, if they're civilians, is a war crime of attacking civilians. Attacking schools is a war crime unless they're being used for military purposes. Fourth, the use of child soldiers, and that's not just use to play some role in a military force, and it's not even just used for combat. For lots of them, it's use as suicide bombers. Reportedly, more than 200 between 2017 and 2019. The recruitment, conscription, and use of child soldiers are all war crimes. In fact, the International Criminal Court's first conviction was exclusively for crimes against child soldiers. Fifth, gender-based crimes. I think the Chibok kidnapping, again, is emblematic here. Young women completing their education were targeted. Various international reports identify patterns of sexual and gender-based violence. Evidence includes crimes of rape, sexual slavery, and forced pregnancy as both crimes against humanity and war crimes, as well as persecution and forced marriage as crimes against humanity. So very serious allegations again. Sixth case, attacks on religious buildings, mosques, and churches. The ICC's third conviction was just about the destruction of such cultural sites. As the former prosecutor Fatou Bensouda said at the time, attacks like this are what she described, quote, a profound attack on the identity, the memory, and therefore the future of entire populations. That's the sixth case. And seventh, attacks on humanitarian workers, which seem to include, at least when it comes to Boko Haram, attacks in 2011 and 2018. Targeting humanitarian aid workers is a war crime. So that's the 7 cases. And it's just the 7 cases that have been identified with regard to potential responsibility for Boko Haram members. That's not the only group alleged to have responsibility for some crimes in Nigeria during the relevant period, but it's the one I've studied, so it's the one I'm talking to you about today. It's the one I've studied on the basis of these public reports at this stage of the proceeding. So I want to make 2 observations about these 7 cases. The first, as I say in the chapter, is to say that under ICC OTP's approach, it really ties things together a little bit better for OTP to be explicit that the targeting and persecution of Nigerian Christians is its own case, and that tells you a little bit about doing these investigations. So first, OTP found, going back to 2013, indications that Christians were being targeted. And there are easy things to point to. Statements from the late Boko Haram leader, Shekau, that, quote, this is a war against Christians and their democracy and their constitution, and his statement after the Chibok kidnapping that included 4 simple words, we are anti-Christian. The US, the Office of the Prosecutor itself, the Nigerian government have concluded Boko Haram is targeting Christians, and Open Doors USA concluded, thinking about gravity and scale of the crimes a couple of years ago, that more Christians are murdered for their faith in Nigeria than in any other country. This fits sort of uneasily in the other cases. Some mosques have been targeted too, and so the case for targeting of religious institutions is not just about churches, not just about the targeting of Christians. And like many groups that attack civilians, Boko Haram attacks lots of different types of civilians. But the plan to target Christians for violence, to wage war against Christians, fits best as a case that is investigated together and includes crimes that also fit in the others. Imagine an attack on a village. Civilians are killed, a church is burned down, children are kidnapped and forced to join the invading army, and people are subjected to sexual violence. It doesn't make sense to think of that one attack as 5 cases. And it's not how you would investigate it. It makes sense to think of that attack as targeting the village and the type of people who lived there and investigate it together. But second, when ICC considers gravity and complementarity, so if you're thinking about patterns of conduct, you should be thinking about the broad pattern that motivates several of these specific types of crimes that ICC OTP is divided up. So my first suggestion about cases is they're describing it in a way that's a little bit inconsistent. But second is when ICC considers gravity and complementarity, those admissibility factors, to decide whether a case is admissible, it does so in terms of cases against individual perpetrators. Perhaps at the leadership level, it makes sense to think, would it meet our standard? Would it be admissible to have a case about the targeting of all the religious buildings? But there are people who have responsibility for targeting individual religious buildings. And it's the cases against particular defendants that ICC will decide whether they're grave enough, whether it's being handled by a domestic court, whether it's admissible or inadmissible at ICC. So doing a little bit more granular analysis would be helpful in thinking about whether they have cases that are going to meet the admissibility standard, whether it's worth moving forward from preliminary examination to investigation. So those are, I think, the two big kind of insights about how they treat cases and the identification of cases at this stage of the process that come out of closely analyzing this particular situation. But there are also important lessons that this situation provides for us on the two admissibility principles, gravity and complementarity. So gravity, again, talking about that one first, is the rule that ICC only takes cases that are bad enough, essentially, to justify its exercise of jurisdiction. And in fact, when ICC conducted an independent expert review 4 or 5 years ago, one of the things that it focused on was taking only the worst of the worst. What the experts wrote in their recommendations was the OTP should focus on a narrower range of situations and limit their interventions to the extent possible, focusing on situations of the highest gravity and on those most responsible for the crimes. They say the prosecutor should adopt a higher threshold for the gravity of the crimes alleged to have been perpetrated, and gravity should be taken out essentially throughout the process. So that's one reason that I've emphasized the gravity and the unusual gravity of some of these crimes that they've found reason to believe were committed as I went through the first parts of my talk, to suggest that this is, in fact, at not just something that meets a test for gravity viewed in isolation, but it's something that there's reason to believe is at the highest level of gravity, even compared to the other situations that the court has in front of it. Now, those recommendations were intended to push OTP to put resources towards the most serious situations and reflected a sense that the court was overextended. It was doing too much, spreading itself too thin, and needed to really focus on the worst of the worst. So what would they tell us here? If we look at the gravity factors that the Office of the Prosecutor has identified, they break it down into basically 4 categories. The scale of the crime, meaning the number of direct and indirect victims and the extent of damage to them, and the geographic and temporal spread of the crimes. Here, you're looking at high numbers of victims, more than 10,000 killed, thousands abducted, a high extent of damage. Many, again, lots of them killed, thousands of them killed. Others, many others, subjected to rape, torture, or long-term abduction. A high temporal spread of criminality, so going on for a long time, more than 10 years. The 2013 Article 5 report that I cited earlier, the report 10 years ago, that found that there were these serious crimes being committed, or reason to believe that these serious crimes were being committed, found Boko Haram was able to launch attacks around the country. So geographic and temporal spread, serious damage, high numbers of victims. Second thing they look at, nature. And the crimes that they find are gravest in nature are killings, sexual and gender-based crimes, crimes against children, identity-based crimes like persecution and genocide. And here we have killings, acts of sexual and gender-based violence, crimes against children, identity-based crimes. Really, almost all the crimes that are gravest in nature included in this investigation, or this preliminary examination still at this point, this not yet an investigation. Third, the manner of commitment, including particular cruelty, as well as abuse of power, discriminatory intent, vulnerability of victims. And again, you have allegations like persecution that require discriminatory intent, allegations of targeting particularly vulnerable child victims, targeting female victims, including for sexual and gender-based violence, the targeting of protected objects, including schools and churches and mosques, as well as a systematic pattern of crimes and a link to an organizational policy or plan. So again, in terms of manner of commission, lots of the factors suggest high levels of gravity here. And finally, in terms of impact, thousands have killed people. Obviously, the impacts on them and their families are incredibly serious. In terms of other crimes, OTP has emphasized, in Lubanga, for instance, the impact of the use of child soldiers and how grave that was. Emphasized in Almaty, I quoted a little bit of it earlier, the impact of the targeting of cultural sites and how grave consequently that is. Setting those kind of principles aside for a second, those hundreds of attacks on schools reportedly led to school being canceled for years in one province. Obviously, that has a huge impact on the children who live there. So all those four factors together suggest if you're trying to push the court to consider the most serious situations, this is one that it should be focusing on. The gravity says they should be moving forward. Why aren't they? Well, the statement that the prosecutor gave 2.5 years ago said, we've determined that complementarity isn't a bar to moving forward. Maybe it's part of the reason, but that wouldn't be consistent with the statement. But let's talk about some of the complementarity issues this raises. So putting it in the direct terms of the statute, a case isn't admissible at ICC under the principle of complementarity if it is being investigated or prosecuted by a state which has jurisdiction over it, unless that state is unwilling or unable genuinely to carry out the investigation or prosecution. So in this case, OTP has noted in its reports ongoing domestic proceedings against Boko Haram members in Nigeria, but they found there were some challenges and limitations to those proceedings. It said they are limited in scope and depth. Some things aren't against the law. The armed conflict is continuing. The files aren't adequate. There's too much reliance on confessions. And often cases, they say, aren't moving forward quickly enough. And they note that the mass trials in a place called Kenji, this is in their 2017 preliminary examination report, they note that the conviction rate was very low, about 8%. They said, essentially, these are cases that either aren't about the same conduct we would be hearing or against low-level perpetrators. So one question that this raises, because Prosecutor Bensouda, and I quoted this earlier, said, none of these proceedings relate even indirectly to the forms of conduct or categories of persons that would likely form the focus of our investigations at ICC. And the question you would ask about that, I think, is if none of them relate even indirectly, there's no relationship between these domestic cases and the cases ICC would do. How do you square that with the fact that it took 7 years for ICC to come to that conclusion, and the fact that the prosecutor had explained the delay in the case by saying, we were trying to support the Nigerian domestic authorities. And one answer is that the statement and the reports don't perfectly line up. That the Nigerian government has taken some actions, for instance, setting up special investigations on sexual and gender-based violence and a specialized unit to investigate and prosecute Boko Haram crimes, including at least 2 of the perpetrators of the Chibok kidnapping who've been sentenced, and a large-scale reintegration program for former Boko Haram fighters. However, for at least many, the report indicates that OTP may have concluded the Nigerian proceedings eventually failed what's called the same conduct test. And that test, which has been subject to some criticism, holds that you have to charge somebody in the domestic proceeding for the same conduct as at ICC, or there's no complementarity issue. So if you charge somebody, for instance, with terrorism in a domestic court, and ICC also sees that in the course of their involvement with the terrorist group, they've been involved in crimes of sexual and gender-based violence, ICC can try them separately. Second, OTP may have concerns about the domestic proceedings in Nigeria, which have been subject themselves to international criticism on due process kind of grounds. Whatever the reason is, OTP will face several of the same challenges if it eventually moves to an investigation. Again, it had looked at the armed conflict continuing. That will still be the case. Inadequate investigative files. I mean, it'll be going back and trying to generate this evidence for crimes that get further and further into the past. And evidence, particularly evidence you have not collected yet, does not get better if you wait 10, 15 years to collect it. It's far more likely to disappear. These problems are only likely to be fixed by an ICC investigation if Nigeria has simply chosen not to look for key evidence, which seems unlikely. That evidence still exists, which seems highly questionable. Or OTP would get access perhaps through partners to evidence Nigeria wouldn't be able to, which seems possible, but again, questionable. So here, I think, while OTP has concluded that under the law, complementarity may be satisfied and it may be able to go forward, bring admissible cases, the fact that Nigerian proceedings have these challenges and that ICC proceedings would have the same ones may be a substantial motivation for them not moving forward more quickly, letting this remain in limbo for 2.5 years. But keeping in mind that that evidence won't get better, keeping in mind that this is one of the most serious situations that the court would ever have considered, keeping in mind those thousands and thousands of killed victims, the thousands more abducted as part of these massive patterns of criminality, keeping in mind that this falls at the high end of all the court's gravity factors, and the court is being pushed to consider the situations that fall at the top of that scale. It's really surprising that the situation remains in limbo. It's surprising that it's not talked about more in the international criminal law community. And it's something the court should take action on, should explain, should move forward to a formal investigation. All right, that's more than enough from me. I'd be excited to take questions, Luisa, Valentina, or anybody else. And I'll look forward to that. Thanks for your time and attention so far.
Thank you so much, Arthur, for this amazing lecture. And the first question is in regards of armed groups. So could you talk more about how to determine individual responsibility when dealing with non-state actors, how to surpass the lack of information about their internal organization, and what criteria do you think would be better when prioritizing cases?
I think that's a great question. And it gets at something that international tribunals have struggled with. Groups that have less documentation or a less formal chain of command, it's been harder for international courts to link crimes to the top level of leadership, the people that you might think are most responsible. In this case, I think there are a couple of things that are worth noting when we think about how big a concern that would be or wouldn't be. First, 10 years ago in that 2013 report, OTP was already able to conclude publicly, based on the study that it said it had done, that Boko Haram was under a responsible command, under the command of this guy Shekau at the time. And so they understood at least enough about its functioning to know that. Second, this is a group that's been investigated by a number of governments and countries, I would imagine, based on its activities. There is information and expertise about how it functions, about how orders are given, about what its goals are. And collaborating properly with partners, you can understand the structure of that group. The fact that you don't have quite the same maybe documentary trail as you would for an official military is, I think, in this case, probably not an insurmountable hurdle. The third thing to say is, look, it has the misfortune, as non-state armed groups go, of committing lots of those crimes, allegedly, committing lots of those crimes at a time when its members probably communicated about them electronically in a way that can be investigated, and that different states probably have collected some evidence about those electronic communications, and some of those states, probably ICC members, some of those states probably willing and able to share some of it with the Office of the Prosecutor. In terms of, that's my answer on the non-state armed groups. Bottom line, it's a good question. It is often harder. In this case, I think ICC claims that it had figured out things about this group's structure, and there's reason to believe that there's more evidence available. In terms of how that fits with prioritizing, or what would be a better way of prioritizing cases, I think if you're talking about situations, I share the independent expert review's view that you should be prioritizing the worst of the worst if you're going to satisfy the reasons that the court was set up in the first place. The other thing I think you should be prioritizing are situations and crimes that are really at the core rather than the periphery of the court's jurisdiction. So there's no reason for the court to reach out to take on crimes or situations or cases that are kind of jurisdictionally questionable when there's really important stuff at the high end of the gravity scale, right in kind of its jurisdictional heartland, where there's no real dispute about it. So you can prioritize those in a way that allows, hopefully, for the court to do some good, do some cases it definitely has jurisdiction over, and build up a record of success. And if it's concerned about universalizing, as its strategy says it is, then doing those core cases, demonstrating value, demonstrating success, demonstrating something that the remaining states want to join, I think is the right way to go about it.
Perfect. The second question is from Valentina, and she wants to know that if you can explain better about the criterion of sufficient gravity, if it's more subjective or it has an objective requirement to be considered.
That's a good question. So there's an objective component to it for sure, in that there are concrete factors that you have to think about. And if you're considering the scale of the crimes, for instance, then there are objective facts, right? Numbers of victims are objective. Which crimes are committed are objective. There's some part that's more qualitative than quantitative, right? But I think still objective. I think where the court says, in terms of where the Office of the Prosecutor says, in terms of the nature of crimes, look, the gravest crimes, well, there's no hierarchy in international criminal law, courts say all the time, but crimes of murder, crimes of sexual violence, crimes of discrimination are more serious than other types of crimes. And that pushes you higher up the gravity scale. I think that too, while it's qualitative rather than quantitative, is an objective kind of criteria. So a fair bit of it, I think, is objective. Here, the independent expert review and some of the court's jurisprudence butt up against each other. And I should be frank about that. There's at least one chamber of the court that has basically said the gravity standard means almost everything that falls within the Rome statute is grave enough and you should go forward. It's only really exceptional cases that don't meet the gravity threshold. But that's exactly the independent expert review kind of implicitly tells you. It's that kind of thinking that has led to an overstretched, overextended court that is in too many places, not doing enough in any of them, and not even able to move forward after almost 15 years in this situation that by those objective criteria, again, falls just at the top of the gravity scale. And so there's a real need under its own principles to move forward here. And this overstretched approach is preventing it from doing so.
The third question is from Julio Veiga, and it is, and what about the contextual element policy for crimes against humanity allegedly committed by non-state actors? Is the threshold much different, lower or higher in comparison to state actors?
So I think the court is figuring out what's meant by policy. In this case, there's the former president, a Nigerian, the former president, Judge Ebo Osuji, had an opinion that took a very broad view to what's an organizational policy for purposes of that contextual factor. But for me, I think you would need an organization to feel safe as a prosecutor anyway. You'd need an organization that had a policy, and you'd need some kind of clear indication of what that policy was. And I'd say that can come in a couple of different ways. It doesn't have to come from a statement. It can come from a persistent enough pattern of conduct. But here, it appears to me that in terms of at least several of the aspects of crimes against humanity, you have explicit organizational statements. You have long-term patterns of conduct that at least provide reason to believe, at least provide sufficient basis to think, well, if we move forward to an investigation, collect evidence, go to trial, we've got a shot at meeting our burden. Again, all of this stuff is at the allegations stage, so I don't mean to suggest that any of it's been proven beyond a reasonable doubt by what they've put in these reports without it being vetted by cross-examination, by the defense testing the evidence, by all the things we expect in a proper criminal trial. But for what you'd expect at this stage of the process, the evidence they have looks pretty good. And it looks pretty good compared to what you'd expect either from a state or a non-armed group. I mean, you'd be looking at explicit statements of policy by leadership, explicit statements by the organization, whether it's a state organization or a non-state one, and these long-term patterns of conduct. And it seems at least that there's reason to believe those might all be provable here.
A non-named user sent a question. You talked about how COVID affected the international community's examination of the situation in Nigeria. Is there any data on how COVID affected the performance of groups like Boko Haram?
Oh, that's a great question. I have no idea what the answer is, but that's a great question. And it's something I'm going to make a note for myself to look into. One thing that I will note is there is data that says it affected the performance of the Nigerian court system, that there were massive COVID-related backlogs at exactly the time that ICC was determining that Nigeria wasn't doing these cases itself. And so that too may be part of not immediately moving forward on ICC's part.
A question that comes from Leticia Heisman. In the case of terrorist groups, when this categorization can be used as an argument that the case is not being properly dealt with at the national level and should be handed over to the ICC?
So I think a couple of things. For the ICC's purposes, I think the relevant categorization is when a terrorist group is also a non-state armed group, as Boko Haram, ICC OTP has found is. And one participating in an armed conflict or waging this kind of large-scale attack directed at civilians that allows you to get within ICC jurisdiction. Because the ICC, for reasons related to some of the member states' politics, the ICC chose not to include terrorism among the crimes that it can prosecute back in 1998 when the Rome Statute was drafted. But I think one of the things that is relevant here, I think stepping back from that, I think you'd expect it to be judged in kind of the same way. If it's a terrorist group that's also a non-state armed group, if it's a regular non-state armed group, if it's an army, the question is, are the cases being dealt with at the national level or not? Are they being dealt with under the relevant laws at the national level? That is, are they just prosecuting people for terrorism, or are they prosecuting them also for substantive offenses? And I think you'd apply that the same way to members of all groups.
And one last and the biggest question ever. There are two together. It's from Julio Veiga. Considering the gravity of the situation involving the Boko Haram, could the participation of victims in the proceedings before the PTT play a crucial role for the opening an investigation? In your opinion, could or should victims have stronger voice in these proceedings? Is the representation of victims at the ICC sufficiently equipped for cases such as this one?
I think that's a great set of questions. So I think I'll say a couple of things. First, to be fair to ICC, I think it has a strong victims representation office, and victims' own representatives, that is not the prosecutors, but lawyers directly representing victims, are present in court regularly. That's not something we have in my own domestic system, for instance, and it's not something we had at ICCY. While those of us in the prosecutor's office particularly were very concerned with doing enough to live up to the courage of the people who'd come to testify for us, our obligations were obligations that prosecutors have, not obligations as the victim's own attorneys. So I think it's good and a step forward that ICC has that. That said, we're at a kind of odd procedural stage here, and I think I said it's unprecedented that there's this 2.5-year wait for so far after the Office of the Prosecutor says there's enough material to go forward, enough evidence to go forward to an investigation, but without them doing it. And I think if I was one of the victims and closely following this, I'd be looking for ways to have a voice and nudge them to move forwards, nudge them to do what they said the evidence allowed them to do 2.5 years ago. And because this is not really, because there's no chamber yet seized of the issue of whether to move forward to an investigation, it's very hard for victims to find the right avenue to do that.
So Arthur, thank you so much for this amazing presentation. It's very nice to have you back here with us in the clinic, and I hope that you can talk much more in for future events with us. And that's it. Thank you so much, and it was a pleasure to have you.
Thanks so much for having me and for the great questions. Have a great evening and a wonderful weekend.